Welcome to this webinar, which is one in a series being arranged by the Office of Cybersecurity and Information Assurance for Cyber Month in October 2020. My name is Ian MacDonald. I am the Isle of Man's Information Commissioner responsible for data protection legislation and freedom of information legislation in the island. Today's webinar is entitled, Where is your personal data? And intends to look at a number of factors to do with what happened during lockdown and what your future plans may be. So if I may, I would just like to share my presentation with you at this moment in time. As I said, the presentation is titled, Where is your personal data? And I intend to look at what processing personal data occurred during lockdown, what that may have implications that may have for any future plans of your business, and indeed the implications that may be for international transfers that occurred due to a decision of the Court of Justice of the European Union that occurred in July, which you may have missed because of the other issues that we're all dealing with. So starting with processing during lockdown, I think I chose this image because I think it sort of fairly accurately reflects how we all managed to continue to operate during the lockdown, and we found some bizarre, albeit successful, places to carry on working from home. And that is generally the case. Most businesses are reporting that their continuity plans were successful, operated successfully, albeit may not have been, the continuity plan may not have been developed to consider a global pandemic and global shutdown of offices. But in general, continuity plans have worked. Indeed, many companies are reporting not only same levels of customer satisfaction, but on many occasions increased levels of customer satisfaction. Again, companies are seeing improved productivity, which given where we were at the start of lockdown, most people were concerned that staff would take advantage of working from home, whereas the opposite appears to have been proven and that productivity has increased. And indeed with that, generally staff are content. Most staff have actually enjoyed the experience of working from home. Not all, but most. And many wish to continue to work from home, albeit maybe on a part-time basis or on a semi-permanent basis. And indeed, there are still many businesses whose staff are working from home at this moment in time. One thing I think we can all say is that the big success of the lockdown has been the provision of cloud and network services, which has been pretty successful, including the advent of video conferencing as a tool to communicate with staff. However, not everything was rosy, and indeed my office has reports of companies that have been unable to access systems and or critical files. We've had reports of data transfers that have occurred using insecure email or insecure third-party applications, which in themselves have another problem in the fact that the data, you're not quite sure where it has gone to and who else may have access to it. We also know that data has been transferred to personal devices, which in itself presents security issues for that data. And that's not just limited personal data, that's obviously all types of data that may belong to the company. We're aware that some people have been working on insecure networks, particularly the security around home routers may not have been to the standard required by the business or indeed for the level of sensitivity of the data that was being processed. Equally, some home devices have been insecure, not just from sort of misuse by a third party, but also because they've been shared, perhaps being used by children to access their schoolwork, which has inherent risks with the security of the data that may be on that device. Equally worrying is the fact that even though some companies may have reported great success with their continuity plans, they failed to comply with access rights. We have a number of cases where companies have not complied with subject access rights during lockdown, and I've quoted COVID as a reason for not doing so. that is not an excuse, and indeed, where a company boasts that it has worked perfectly well digitally during lockdown, there's no reason why they couldn't at least access their digital records in exactly the same way as they could carry on their normal services. We do accept that there was issues with the manual records, and indeed there are some people that have ongoing issues with access to manual records. But again, that is not an excuse. But again, it's one of those things. These are all these issues are the issues that need to be looked at if your future plans are to continue to operate differently or in a similar fashion to which we have operated during lockdown. And that's the key. What are your future plans? How many of your businesses are considering actually this work-home life balance where staff may be able to work for longer hours at home or several days at home, maybe a couple of days in the office, a few days at home? Is it on the short term, medium term, or is that actually going to be a permanent decision? Regardless of what those plans are, you will need to consider your processing of personal data and how that complies with your obligations under the data protection legislation. The main issues that you need to look at are the Article 5, which is accountability. That's the accountability of your compliance with all the data processing principles. So, yeah, are you processing data fairly? Are you processing it in a transparent manner? And are you processing it lawfully? Is it being limited to that which is necessary for the purpose? Is it accurate? Is it up to date? And is it secure? So that's what you need to demonstrate via your accountability principle. You will need to look at your policies and procedures. An obvious one for home working is does staff have greater awareness of the responsibility to ensure the data is secure, the data remains accurate? For example, I don't have a changed copy of a file on my home PC and I haven't updated the network file that everybody else in the business has access to. Or am I keeping a file on my PC when it is actually out of date? You still have to think about data protection by design and default. You can't say, oh, because we're home working, we will ignore something and not have proper data protection processes in place. They are still your obligation by design and default to have proper data protection measures in place. And of course, you will need to update your processing records accordingly to reflect whatever processing you're now undertaking. All of that, of course, will feed into your security processing. What appropriate technical and organizational measures do you need to have in place to reflect that processing? For example, maybe staff are required to be provided computers from work. Perhaps staff need to actually have their routers replaced by routers provided by work that actually meet the security standards of the office. At all times you need to think back to those four keywords: confidentiality, integrity, availability, and resilience. So those are the keys for your future plans going forward. You need to actually think of that again and go back and look, with the lessons from lockdown, what is it that we are going to do in the future, and what do we need to ensure that we're still compliant with our legal obligations? And of course, the easiest and probably most effective way to do that is to undertake a data protection impact assessment. Further information about a data protection impact assessment can be found on our website, and the web link has been provided to you in the presentation. And of course, looking back, what is it that you're trying to actually achieve? That the staff are working with proper technology, that the connections to the business are secure, that staff have clear expectations as to what their responsibilities are and what they have to do. There's proper communications programs in place. There's clearly a trust issue that needs to be set up and maintained between staff and the employer. And of course, you continue to continually test the effectiveness of all these policies and procedures. No different than what the data protection legislation actually says. So those are the issues going forward. Moving on to that final third topic, the international transfers. During lockdown, or shortly after lockdown, the Court of Justice of the European Union published its decision in Schrems 2. For those that are unfamiliar with Schrems, Max Schrems is an Austrian lawyer who several years ago challenged the original US personal data transfer mechanism that was known as Safe Harbour. And eventually the Court of Justice of the European Union ruled that Safe Harbour was invalid, and that was replaced by the Privacy Shield. With the advent of GDPR, Max Schrems again challenged the validity of the Privacy Shield via the Irish Data Protection Authority, who in turn referred it firstly to the Dublin courts, who in turn referred it to the Court of Justice of the European Union. The decision of the Court of Justice was issued in July. The press release could be found at the following link, and indeed the European Data Protection Board statement, that's the board that consists of all the European data protection authorities in Europe, including the European Commission, and their statement can be found at the web links that is published as well. And it's important that you continue to look at the European Data Protection Board website, as they have established task force to look at the Court of Justice of the European Union's decision and consider the best way forward for transfers of personal data as a result. But what does the CJEU decision say? Well, in summary, it invalidates the US Privacy Shield. But it also goes on to question the validity of standard contractual clauses and binding corporate rules where they are used to transfer personal data to other third countries, and where that third country's laws would override those clauses or rules. In fact, what it is saying is, if the third country's laws can override these, then you haven't got an adequate level of protection for the transfer of personal data from the European Union. That may have implications for Brexit going forward, but again, that is another matter for another day. But it is something to keep at the back of your mind. So what is the practical implications for now? Well, very simply, you will need to review your international transfers. The first thing you need to do is determine, well, am I transferring data to a controller in the United States? And if so, was I relying on the Privacy Shield to do so? Now, this may not be as obvious as you may think, because you will have to look at your third-party applications such as Facebook, LinkedIn, Twitter. These applications may mean that you have been transferring personal data to the United States without really appreciating it. So you may need to look at your use of those applications. The first thing to do is, if you have been relying on the Privacy Shield, is to look for alternatives. And you need to remember that there are several derogations set out, firstly in the Article 49 of the applied GDPR, and then in the case of LMAN in Schedule 10 of the GDPR and LED implementing regulations. Those derogations allow for example, transfer directly to the data subjects. So if you have a customer, for example, in the United States, and you transfer personal data directly to that customer, the derogations apply. You don't need to look for an alternative. Equally, there are provisions in Schedule 10 to allow for example, tax information exchange agreements. So the first protocol is look at those. Okay. The other thing that you need to do is, if you have had a reliance on standard contractual clauses, and probably less so in LMAN and binding corporate rules, you need to look at that country and say, does that give appropriate safeguards? If not, you may need to look again at what that transfer is. That basically is all that I have to say in this webinar. I mean, obviously, in most presentations, we finish with a question and answer session, which is not really possible in this scenario. So therefore, if you have any questions that do arise out of this webinar, well, please email them to us at ask@inforights.im, and we will endeavour to answer them. I hope that this webinar has been informative and given you a very brief update on events that have happened during lockdown. Thank you for listening.